Yes.
Adjournment request, if any, from item number 1 to 7.
So item number 6, my lord, some difficulties of a senior, my lord.
Seven. Adjournment slip has been circulated. All right, give them the date.
19 March. From item number 8 to 13, adjournment request. Any other request?
May I please, your lordship? I am praying for listing of a matter for withdrawal, lordship, on 27th, lordship.
Yeah.
If you-
May I please, your lordship, I beg to mention item number 4. One IA has been filed. It may be called for.
Item number 4.
Yes.
All right. We'll have it.
I.
Hi, Mohan.
Thank you.
Huh?
Maybe but the problem we keep create and keep problem. So we can
No, it'll have to go to another day.
Hmm.
You filed it on behalf of the respondent.
Yes.
Which is
Respondent number 1.
respondent number 1? Yeah, as prayed for on behalf of respondent number 1, let this matter come up on. We fix it on 27th only. 27th we can.
I'm the appellant here.
I
I'm the appellant here. Not, I thought, my lord, the case will be taken up.
That's
only
right.
here.
She has filed some affidavit which is not on record.
will find.
So therefore, we can't have it summoned here in the IA. Therefore, we are fixing a date on 27th, on the day when the court is opening after independence. I mean, what is that called? Republic Day.
Well, attempt for disposal, my lord, because
That's right.
a short question, my lord. Very
We are
short
ready to hear you,
Well-
but we can't hear without the
Suddenly
other
I'm
side.
caught by surprise because my item has been mentioned without informing me.
You should, when you make such, she was not asking for adjournment.
That is the.
She was not asking for adjournment. She has
Yes, sir.
only asked for that document to be brought here.
I-
That is not
Correct.
possible,
No,
therefore.
I'm
we
not
are-
blaming her. I'm suddenly
All right.
was caught surprise.
27th. 27th is all right?
27 is the.
Maybe, your lordship. Lordship, praying for a listing of a matter, your lordship. It's a hearing matter. Lordship, what I want to mention that, lordship, the matter is in the part 2 hearing list as item number 172. Lordship, there is some urgency, lordship. We
What
have
is the
also,
urgency?
lordship, what happens, lordship, we have challenged this gradation list against some private respondents in a PWD department. So, lordship, what happened? We are the direct recruitees. They are the promotees. Now they have been held in above us in a gradation list.
On some hearing date.
Hmm.
Will fix it down.
Now they are giving
Just-
effect to the promotion.
Right. Gradation list dispute has to be heard. So we keep it on 12th of February.
12th of February, Lordship. Much obliged.
Supplementary list for orders, item 14.
Who number?
Yes,
My lord,
Yes,
I have collected the similar pending minor table number that is 171 2023.
give the number. Let this review petition be listed along with so and so on. What is the date?
My lord, no date fixed after.
No, there is a date. You
Where
can
is the
find
date?
it out.
Find out and tell us.
Yes.
You have done half, it's half baked
My lord, I
information.
have searched, my lord, no date is.
You find out,
Or last is the
you find out and let him know
Okay.
later.
Slip. Item 15,
on the number 4. इसमें देखिए आगे
Yes, you appear for whom?
I am appear for the statement, deputy.
State.
Right.
Respond number 4 has not been served.
Yes,
Let fresh notices be issued. To respond number 4. Let fresh notice be issued to respond number 4 on steps being taken by the petitioner within a period of 2 weeks including furnishing of the correct address of the noticee, correct and present address of the noticee, both modes returnable,
Yeah.
margin.
25.
Your Lordship. Your Lordship, on the last,
Some documents have to be.
My lord, we
brought on
got
record.
the document. my
But
lord.
we have not taken note of that. That's
No,
why a
fine.
predecessor bench
25-3.
ensure that those documents are here.
My lord, that is,
Otherwise, in deference of the court's order, we'll have to ask for the presence of somebody.
my lord, that document has already been, well.
Master.
What is it? Where is that advocate? Fix it.
there also, yeah.
Anyway, fix it sometime in mid-term.
Yes, sir, sir.
19 February.
Depends
You're right.
on-
19 February. Item 16 to 35. 14.
Why is it come for order?
No, this is fixed all year. In fact, item number 16, there's an office note. I have checked up the office note. The speed post is already delivered, but in fact, Malad, the person concerned is residing at Manipur. Not, can it be Malad by way of Dusty so that it will be
Which respondent?
that sole respondent Malad? He's a native of Manipur Malad. So we will be
Item number 16.
ये बात है because the last two items and we keep
Who are appearing in the other matter?
in other matter one. Tapadar is one Prabhildar is
In
available.
item number 16, take down. Okay. At the request of the learned counsel for the
कौन? बता दे।
petitioner / Union of India. It is directed that notice on the civil respondent be served thusly, for which necessary requisites shall be filed by the petitioner / Union of India within a period of 1 week. Semicolon, whereafter. Mr. Tavindar, you are appearing for us, number 1, in item number 16.
Item number 16, I am not preparing. That's it. In these, all these matters, actually, I appeared before the Armed Forces Tribunal.
That's right. So
And in item, all the, most of the clients, that's it, they have contacted me over telephone. And in some of, on 9 cases, out of this, on 9 cases, I have filed my Wakalatnama also. So Lordship, though they have contacted me, they could not come due to the ethnic violence of the
I'm asking you something else.
Lordship.
In this case, in item number 16, the respondent has not been served.
Yes,
So
Lordship.
would you undertake to inform him?
Yeah, I'll inform Lordship. But otherwise, Lordship, may I pray one thing, Lordship? In the other 9 matters, that may be Lordship taken up for hearing any short dates or because it's pending, and others, Lordship, maybe for others, Lordship.
No. We'll hear it. I mean, no piecemeal.
And the decision has already been taken by Honorable Supreme Court in these matters.
All right. So I don't think we have to rake up our brains more than what is
Yes,
required.
already Delhi High Court and similar matters, the AFT has filed before the
All
Delhi
right,
High Court.
okay. So in this case, I think he will be appearing.
Malad.
No, Lordship, I'll inform them. Lordship, now my appearance may not be given in item number 16. I'll inform.
In all the cases listed today, except item number 16, except WPC number 6262 of 2025, the service of notice is complete. The respondent in the aforementioned writ petition has not yet been served. Since Mr. A.R. Tabildar, learned advocate, has appeared for the other respondents, for the respondents in other cases, he undertakes to inform the respondent in the present case to inform the respondent in the present case, in the aforementioned case, for his appearance in the matter. For his appearance in the matter for contesting these set of petitions.
Right.
Let all the cases be listed under the appropriate, all the cases be listed under the appropriate heading upon. We give it in first week of March, or even before that. No, the first week of March.
Obliged.
10th March.
Obliged.
Daily list for admission, item 1 and 2.
Item 1 and 2, Lordship, may kindly take up this matter after some time, Lordship. After some time.
अभी past में pending बोल के, दोनों को
Your Lordship, today is the matter fixed for final disposal.
where is Mr. Not
He is-
listed, some instructions for the
Yeah.
next case.
Next.
336. Very good.
Acha, the accountant, brother, the accountant,
20 minutes.
any decision has been taken by the government?
Lordship, as per instruction, Lordship, no decision has been taken, Lord.
That was one of the directions
Yes.
in the impugned judgment, which we would definitely not interfere with.
It's true, Lord.
Next week,
Take instructions about this.
Lordship.
Who's, Mr. Das is appearing.
Lordship.
He is leading you.
Lordship.
So ask Mr. Das to take information
Lordship.
whether the directions for the state to have taken some measure
Look.
for amending the rules,
Lordship.
for bringing the accountants also in the feeder pool. For the reason that they are working as head assistants.
Lord.
And they have been working for a long time.
Lordship.
They should not be bereft of
Lord.
any promotional advantages.
Lord.
Something had to be done. Correct.
Lordship.
So ask him to take all information and then we'll hear it on the next trip.
Lord.
I think we fix this matter sometimes in mid-Feb. Let both the appeals be listed. For a final determination. On
16 February. 16 February.
My lord, on 17. 17.
17.
Item number 3.
May it please your lordship. My lord, I am appearing on behalf of the respondent number 1, my lord. I want to file a small affidavit in this case. Will you
Mr.
give me
Mata,
one-
your affidavit is not ready.
My lord. No, yesterday only, my lord, last night, my lord, I was engaged in this case, man. Although I would argue with the case, me bhoda lana single judge, my lord.
All right.
Section 46 applicable or not, that is the main question here, man.
What happened on 2020? What happened on the
Election hell, we are elected, man.
Now they have elected, my lord.
We are elected.
Now they have been elected.
My lord.
And she is also present, my lord, in the meeting. She was also present.
All right. All right. All right. But we must decide about the quorum.
My lord, no, that regarding quorum, my lord, that quorum, my lord, yes, quorum has to be decided here. But my lord, the adjourned meeting, whether quorum is required or not, that is the question here, my lord.
No, the question there.
Because it is a special meeting for the first meeting. There is no provision in this act, my lord. That
Prima-
section 46 is, my lord.
Prima facie, we have held that was, I mean, that was the argument raised, that was the first meeting. For all practical purposes, it was the first meeting.
My lord,
Therefore, Rule 47 has no application, Rule 46 has application.
no, my
Because
lord,
that's a specific rule,
my lord,
sorry, Rule 48.
48, yes.
Specific rule for election of president and vice president.
That for, yes, and that is the argument before the learned single judge, and the points which are raised before this honorable court, that was not taken before the learned single judge, my lord, by them, my lord.
All right.
I'll file a short affidavit.
Mr. Mahanta, learned senior advocate, submits that he shall be filing the response affidavit by the next day. Re-notify on February only.
My lord,
25 2.
Published, my lord.
For hearing, item 5.
Our lordship, as per the last order, lordship, the government has filed their affidavit, lordship. But perhaps up to that instruction is required in this matter, lordship. Up to 2024 is there, lordship. Lordship, may kindly see the last affidavit. lordship.
Monitor the filling up of the vacancies. Now, there was a special circumstance when this writ petition was taken. It was a suo moto. Are you challenging that suo moto taking up of
No,
this
lordship.
matter?
Subsequently, lordship, the issue has been diverted to lordship constitution of separate investigation in lordship. Criminal investigation. in
The learned counsel for the petitioner admits that a response affidavit is required in connection with the affidavit filed on behalf of the state regarding the status of the unfilled vacancies in the police department. Let such an affidavit be filed for the.
My lord, the additional affidavit which was filed on 37/2025, we have elaborately explained.
Right.
That is up to lordship 2024, lordship. Subsequently.
So we can't make it up to date for every month, no. The issue has been decided, they have been able to understand the necessity of filling up the posts, that's all. We are not here for daily administration monitoring, no. So whatever affidavit you have to file, you file, we will close this.
Look.
Re-notify on, we are filing, we are keeping it in early February.
Look,
No need to keep this pending.
look.
12 February.
God bless you.
Item number 8.
Let this case go out of our list and be placed before a bench of which one of us, bracket Arun Dev Chaudhary J, not a part. List this matter before the Chief Justice on the administrative side for allocation of an appropriate bench.
Item number 9.
Yes, Mr. Bhatti. Today you conclude your arguments.
Yes, sir, definitely, my lord. And I would not take much more time, my lord. Directly, my lord, may I take your lordship to para 7 of the additional affidavit, my lord.
Page,
That page, my lord. Additional affidavit, to know. Yes, my lord, at page 191. And para 7 is at page 193, my.
yes,
My lord, may I read it?
please.
It is humbly submitted that an expert committee on single-use plastic,
Your reading is at page 289.
193, man.
No, that numbering is incorrect.
Ach, there are 7, man.
Yes. Yes,
It is humbly submitted that an expert committee on single-use plastics constituted by Department of Commerce and Petrochemicals, Government of India, recommended for phasing out of identified single-use plastics which had low utility and high adverse environmental impact as early as possible. The following 5 factors of utility were considered by the committee: product safety, essentiality, social impact, and economic impact and hygiene. The following 5 factors have been considered for assessing the adverse environmental impact: collectability, cyclability, end of life solutions, impact of alternative on the environment, and leading propensity. My lord, now, my lord, I am taking to your lordship to the expert committee report that is that that also has been annexed with the original affidavit, my lord. So far, this report is concerned, my lord, that is not eligible in my copy which has been supplied to me, my lord. So that affidavit opposition, your lordship will find at page 40, it starts at page 40, and directly, my lord, I am taking to your lordship at page 40 thereof. It starts at page 40, my lord. And I am taking to your lordship directly at page 64 thereof. Sorry.
You want us to come to the page where there are recommendations.
Yes, expert committee report.
That's right, recommendations.
And at page,
Your pagination does not tally.
my lord, at
Can
page
you,
6,
can you let us know the printed page number on the extreme
printed
right-hand
119, man,
119.
11.
Yes,
Table 2, man.
yes.
Single-use disposable plastic products with utility and environmental adverse impact. Scores. My lord, the iPhone within serial number 7. And I'm manufacturing the glasses and cups more than 100, more than 150 ml and 5G. That is my case, my lord, and that is not covered. First of all, my item is not covered by serial number 7, my lord. And apart from it, your lordship will see
Yes.
apart from your lordship will see that only the item number 15 and 17 have been prohibited by rule 4, sub-rule 2B, and not any other items which have been listed in this 2 have been restricted or, my lord. Now, my lord, your lordship will see, I'm taking to your lordship to serial number 1. Carry bags, instead of directly, my lord, 7, your lordship see the hygiene in respect of item number 7 is 4, productivity 4, essentiality 4, social impact 7, and environmental effect 44, total 23. Apart from it, collectivity 18% and recyclability 15%, ELO solution 16%, alternative impact 17%, and littering prosperity 19%. My lord, if this table 2 is compared with other serial numbers, the similar item have been excluded from the purview of Rule 4, Sub-Rule 2B. Their main strength, and to that effect, my lord, I have also filed the affidavit in reply, my lord. Your lordship may come to my affidavit reply. Merely for the reason, my lord, others have also the equally.
Yes.
My lord, now I am taking to your lordship to my affidavit in reply at page 400 and para 4 onward, my lord. May I read, my lord? Para 4. That first of all, I say that the petitioners manufacture and produce the plastic cups, glasses, trays of more than 5 GMs and above 150 ml. That is not restricted under table 2, my lord. And they were not manufacturing,
The
producing any
table
kind
two
of.
does not talk of restriction. Table 2 gives a comparative scoring with respect to the assessment.
Yes, my lord. That's why, my lord, I am going to make the difference, my lord.
Yes,
Why?
right.
It is violative to Article 14, my lord, as per the classification is concerned. Now, my lord, they were manufacturing and producing any kind of cutlery such as forks, spoons, knives, speech box, inviting cards, cigarette packets, plastic PV banners, less than 100 micron. Thus, the challenge is limited to the items manufactured and produced by the petitioner within the meaning of such and such. With regard to the averment made in paragraph 4, 6, and 9 of the additional affidavit filed by the respondents number 1 and 2 as to high littering potential and low utility of single-use plastic items, I say that the products of the petitioner are not having high littering potential and the utility cannot be undermined as to the use by common people for their day-to-day use. 6 para is very important, my lord. 6 para. That with regard to the amendments made in para 7 and 8 of the additional affidavit filed by the respondents number 1 and 2, I say the expert committee in its report on single-use plastic in table 2 has given the details of single-use disposable plastic products with utility and environmental adverse impact is quote in respect of 40 items, such as serial number such and such, small plastic wherein the quality estimated and determined at 18 is score. Alternatively, impact at 17 is score and little propensity at 19 is score. A bare perusal of the test serial number 4 that it is not in relation to the items produced by the petitioner more than 150 ml and 5 thereby that the items of such and such is more or more is excluded in estimating or determining the utility and environmental adverse impact. Many other items and details that equally indicate such scope. However, no ban is imposed upon them as imposed upon the productive petitioner. Similarly, the environmental adverse impact in the reported PSL stage as to the need of phasing out single-use plastic less than 105, meaning thereby the product of the petitioner is excluded from the purview of the environmental adverse impact. The products of the petitioner can easily be collected and regulated. I say that the products of the petitioners have especially been excluded by the to be phased out immediately. My lord, this is my submission, my lord. And in view of this one, the classification which has been made by under Article 14 of the Constitution, my lord, that is liable to be interfered with by this honorable court now. And secondly, my lord, so far, the doctrine of proportionality is concerned, my lord. I am taking to your lordship to certain paragraphs of the act, my lord, to show that they can otherwise regulate it. The absolute ban is not necessary. For that particular purpose, my lord, may I take your lordship? Rule 5 of the Plastic Waste Management Rules 2016, my lord.
Oh. কোনখন rule?
Yes,
Rule 5 on what, my lord?
of plastic waste management rules.
Management by the urban local bodies in their respective.
1 second, let us come to the. Which section?
Note section my rule 5 of the Assam Waste Management Rule 2016.
No. Assam Waste Management?
Rules 2016.
Have you
The
annexed
the plastic waste management rules, madam, 2006.
Assam? Assam?
Not Assam, madam. Sorry,
Plastic-
sorry, madam.
Huh? Wait, one
The plastic waste management rule 2016.
second. You'll find it 323. Yes,
My lord, rule 5. The plastic waste management by the urban local body in the respective jurisdiction shall be as under. Plastic waste which can be recycled shall be channelized to registered plastic waste recycle or recycling of plastic shall conform to the Indian Census titled as the plastic amended from 2010. So far, my lord, whatever the single-use plastic which I use, my lord, whatever the items I produce, those are subject to recycle. Local bodies shall encourage the use of plastic waste, prepared plastic waste, which cannot be further recycled for road construction as per Indian Road Congress guidelines for emergency recovery of waste to oil, etc. The standards and pollution control norms specified by the Prescribed Authority for these technologies shall be complied with. Thermoset plastic waste shall be processed and disposed of as per the guidelines issued from pollution in enter from cycling or processing facility. Plastic waste shall be disposed of in compliance with the solid waste management rule as amended from time to time. Now, my lord, the responsibility is given to the local body. Every local body shall be responsible for development and setting up of infrastructure for segregation, collection, storage, transportation, processing, and disposal of plastic waste either on its own or by engaging agencies or producers. The local body shall be responsible for setting up operationalization and coordination of waste management system and for performing the associated functions, namely, my lord, that is the rights have been given. Accordingly, responsibility of Gram Panchayat, Rule 7, and 8 is the responsibility of the waste generators, 9 is the responsibility of producers, importers, and that. My lord, the sufficient provisions has been made for collecting the waste and recycling.
that's right. You have made that ground very clear regarding proportionality. But especially in an issue like this, whether you can pitch in this element of proportionality, there has to be a total no. Your first part of the argument, first limb of the argument is very, very acceptable. Second limb, yes, had it not been for complete, what is that called? It's a kind of ecological apocalypse.
So,
That's
my-
why the proportionality theory may not be pitched in.
Even though, my lord, what I submit, my lord, so far, on the base, since the provisions have been made for recycling,
Proportionality theory, can you just find out from that, can you just give us that paragraph from the judgment of the Supreme Court, that Puttaswamy, about proportionality? You have brought it.
my lord, that
The
judgment,
test is very well laid down there. That's one of the grounds now, a newer ground for challenging a legislation.
so my, this being the position, my lord, I pray that at least I may kindly allow, because I am producing.
The
More
fact is this, that you have challenged the rules. You've challenged the rules. You're not asking for any exemption for you. You've challenged the rules on that ground. No, lock, stock, and barrel, you're right. There is some flaw in the reasoning. Now, cups and plates, what you manufacture, have, these have lesser littering capacity. It can be collected also. Collectability also is big because these are big items, not invisible items, which would
Yes.
get lost in the grass or mud. And it can be recycled because it is above 50 microns. To that extent, we have no objection. We follow that. But why is it, Mr. Chaudhary, that you have banned this? You have allowed other things. You have phased it out for 10 years, but you have banned these cups and plates and forks. So these are thicker plastic materials.
Lordship, it has to start somewhere. Although we have identified 40 items, as I have mentioned in my affidavit in opposition, I may take your Lordship to my.
No, you have to see that reasoning is correct.
Yes.
Mr. Chaudhary, we can't question. Yesterday also I used
Yes,
that
sir.
expression.
Yes.
It's like arguing against apple pie, motherhood,
Yes,
something like that.
I do.
It's very difficult.
I
But
do.
what he's talking makes sense, no? Proportionality one, proportionality we may not pitch in here, but then the scores on which you decided, that is very high or low, depending on how you take it, with respect to his products. That's his argument.
Lordship. If I may,
He says that there has been a lack of application of mine and there is a lock, stock, barrel, exclusion or inclusion in that prohibition.
Lordship. If I may take your Lordship to my affidavit, Lordship, at the paragraph 10 of
If you could tell us the page number, it will be more
that
comfortable for
will
us.
be
Printed
to-
or
to-
otherwise, or the
that
new
would be-
numbering.
that would be the correct page number would be 290.
Written by hand.
290.
Internal history of that.
My senior was referring to paragraph 7 of my affidavit. That was on
Yes.
page 289.
Hmm.
I'm referring to paragraph 10.
Hmm.
It is humbly submitted that the petitioner's government claiming that there is intelligible differential to discriminate the SUP items prohibited by the plastic waste management rule, amendment rules notified on 12 so is not factually correct. It is submitted that the expert committee assessed 40 single-use plastic items, which the chart that my friend has shown, of which the items covered under PWN rules were recommended for immediate phase out. There was a study of 40 items. The immediate phase out was based on quantitative criteria in order to reduce pollution caused by littered and unmanaged plastic. Next paragraph. It is humbly submitted that the SUP items prohibited by plastic waste management amendment rules 2021 are littered and therefore cannot be meaningfully collected for any further processing, as has been noted by the petitioner. The plain reading of the word littered makes it clear that any meaningful collection is difficult due to the nature of use of such items. Recognizing the littering propensity, due to which they leak into the environment causing pollution, many countries across the globe have prohibited such items. It is submitted that the SUPs which are collectible and can be processed are not covered under the prohibition. So this is the reference, Lordship. No. And Lordship, if I have understood my senior's submissions correctly, Lordship, he had submitted that he does not fall in the bracket of B. Now, what is B? If he does not fall in the bracket of B, why is he worried?
No, no, you have named his product.
No,
In your,
that-
in your notification, you have named his,
In the report.
you're
No,
talking
no,
about
that is-
report
that is
basic
not- no,
principle,
if
but you
I-
have named it.
If I may read it 1 second, Lordship. B, I'll just read it 1 second. Lordship. Plates, cups, glasses, cutlery such as forks, spoons, knives, straw, trays, wrapping, or packing films around sweet boxes, invitation cards, and secret packets, plastic or PVC banners less than 100 microns. Less than 100 microns.
Less than 100 microns will come. And
So-
what is the thickness of your products, Mr. Bhatti?
Yes, my lord.
What is the thickness of your products?
Micron.
Thickness is more than 5 G, 5 gram. A thickness is
What is
150 micron.
prohibited is everything below 100
100
microns.
It is not.
My lord, in my humble submission, that may not be the correct interpretation of clause, this one, my lord. If your lordship again, read with me, my lord. That is, here your lordship will find packing films around sweet boxes, invitation card, comma. There's the use of comma, my lord. And cigarette packets, plastics or PVC banners less than 100 micron is the SS. My lord,
So you are saying that this 100 microns classification is only for plastic banners.
it is only for cigarette packets, my lord. Plastic and PVC banner less than 100 micron. Because and is it distinctive and comma is also there. So as a whole, it cannot be that in respect of other items, this 100 micron is applicable. And all the products are more than 100 microns, according to just he's issued the information for my client.
Then you don't fall in that prohibited category.
Then,
Then you don't fall in that private category.
then my lord, let it be made clear, by the way.
Why? We don't decide such constitutional issues which you have raised with respect to particular persons. The
100
moment your
micron thing.
factory is stopped,
Uh,
we will not even ask for that clarification from Mr. R.K.D. Chaudhary. The rule is a rule. If it is all above 100 microns, I think you are excluded, at least for the time being. They will ultimately try and phase it out from the environment. It's a very ambitious planning. Can't be done. But beyond 100 microns, I don't think they're touching it now.
My lord,
And common knowledge, of course, common knowledge we can't import here. It is being used every day. In all shamianas and pandals during marriage season, we find that. And nobody has stopped you.
they have stopped me, my
How
lord.
come? Your factory has been closed.
Yes,
Nini. Where is the notification? Did you not say that I don't fall in that category? There are, it is all products
my
are
lord,
above
that
100 microns.
observation may kindly be made, and in that case, I would be
No.
protected, my lord.
We don't create such classes. You say that despite my 100 thing, it is not. This we are not doing. This we are not doing. For our own reasons, for our logical and legal reasoning. We can't do that. That is not what we are called upon. Whether your statement is correct, whether you are manufacturing more than 100 microns, we don't know. We have no wherewithals to decide that. This is your claim. And with this claim, you ask the government that, well, spare us. You have given we have given us the liberty because we are producing anything, I mean, products are more than 100 microns. So you don't raise the objection. Be very clear. If your products are above 100 microns, you are not prohibited. For now, check up, be absolutely sure, make a statement. We will, then we need not go into this academic question.
My lord, in that case, my
Are you
lord,
sure, Mr. Chaudhary?
may I pray, my lord?
Because
Let
the
me-
wording says that it is only 100 microns thing. Otherwise, I'll tell you a fact. Notwithstanding the view, I mean, plastics are dangerous, but then other things which are more dangerous you have included, and cups and plates are too big. Collectability is good.
Lordship, insofar as Lordship, the provision of law is.
See, there has to be some
Aye.
clarity about it. Are you sparing everything of more than 100 microns?
Lordship,
Oh, and then my yeah, from spectator.
So this less than 100 micron stirrers, less than 100. Comma therefore, PVC banners less than 100 micron. और stirrers अलग है. I mean, it is 100 micron stirrers. Praised wrapping, wrapping or packing film around seat boxes, invitation cards, cigarette packets, plastic or PVC banners, or PVC banners. Mr. Chaudhary, please read 2B.
yes, Lordship.
No, it's only for PVC banners. Otherwise, there would not have been a comma thereafter a stirrers. If 100 microns was the test, then this should have been placed after the stirrers. It's like making a statement. I'm not formulating a statement from mine. Can I move? Let's follow. No. In one of the constitutional interpretations, the distinction was made like this. They had made a statement that a tall man and a pregnant woman were going. The tall would apply to man and pregnant would apply to woman, and you can't use both the expressions for both the people. So the way it is written, plates, cups, glasses, cutlery such as forks, spoon, knives, straws, trays, wrapping or packing films around sweet boxes, invitation cards and cigarette packets. No. Plastic or PVC banners less than 100 micron. This is one unit. And then stirrers. P.K. Tripathi. P.K. Tripathi is the author of that book, The Critique of Golaknath, where he has given this example.
If I may just, here, if I may read it once again, Lordship.
Yeah. Whether we go with you or not, that's a different thing. But here it is very clear. 100, less than 100 microns or more than 100 microns, that is to be seen only in case of plastics and banners. Here, Is plates, cup, glass. Cutlery cannot be without requisite thickness. See, a spoon
Yes.
has to be thicker than
Yes.
it must be made. You have stopped all this. And you have lucky. नहीं तो पतला पतला का भी तो बहुत ना होता है सिंगल यूज मिलेगा ना मोटा रहेगा लेकिन यहाँ तो पतला मोटा कुछ नहीं है जैसे दैट इनको then what alternative do you suggest? Because that also alternative product is also one of the issues on which the assessment has been made. Now, for feeding people in public under a marquee, how will you make them drink water?
That is,
Only glass cups, glass only.
but the issue of
Jacket. Material. It's completely non-biological. Recycling potato. Plastic waste management. Now let us come to the preamble of the rule. Just read it out, Mr. Chaudhary. This was notified on 18th of March 2016. Came into force from 18th year. In 2000. Earth from plastic.
if I may read, Lordship, of 2016, Lordship. Whereas the plastic waste management and handling rules 2011 published so and so, dated 4th February 2011 by the Government of India in the erstwhile Ministry of Environment and Forest, as amended from time to time, provided a regulatory framework for management of plastic waste generated in the country. And whereas to implement these rules more effectively and to give trust on plastic waste minimization, source segregation, recycling, involving waste pickers, recyclers, and waste processors in collection of plastic waste from fraction, either from household or from other source of its generation or intermediate material recovery facility, and adopt polluters pay principle for the sustainability of the waste management system. The central government reviewed the existing rules. And whereas in exercise of the powers conferred by Section 6, 8, and 25 of the Environment Protection Act 1986, the draft rules, namely the Plastic Waste Management Rules 2015, were published by the Government of India in the Ministry of Environment and Forest, Climate Change, quite so and so, dated 25 May 2015, in the Gazette of India, inviting objections and suggestions from all persons likely to be affected. Thereby, before the expiry of the period of 60 days, and from the date on which copies of the Gazette containing the said notification were made available to the public, and whereas copies of the said Gazette were made available to the public on 25th May 2015, and whereas the objections and suggestions received within the said period from the public in respect of the said draft rules have been duly considered by the central government.
No, that's right, that's right. We have seen another thing. Now look at this.
Lordship.
We are not supposed to read two in silo. Two is not to be read in exclusion.
Lordship.
The next clause is important. The provisions of sub-rule 2B shall not apply to commodities made of compostable plastic and biodegradable plastics. Now, compostable plastics has been defined in the dictionary of the rules. You will find it at E. Compostable plastics mean plastic that undergoes degradation by biological process during composting to yield CO2, water, inorganic compounds, and so on.
Yes.
So what has been closed? This is what we were looking for.
Lordship.
What has been stopped is non-biodegradable plastic.
Lordship.
This 2A does not apply. Therefore, this answers the classificatory test.
Compostable goods.
Compostable.
Lordship.
The reason is that it is not only the collectability. I mean, we are arguing for you,
Lordship.
Mr. Chaudhary.
I understand.
Otherwise, we were finding it rather difficult because
Lordship.
proportionality theory, what Mr. Bhatti suggested was applying very strongly. But now we did not see this number 3. So it is not all plastics of any. And when it is compostable, look at this. Mr. Chaudhary, you have
Yes.
to look at this. For compostable, there is no direction for any thickness.
No.
The dictionary says so,
Lordship.
correct? So in that case, the classification is correct because it has reasonable, the reasonability of the classification is there. They
Lordship.
don't say everything. They say that use compostable plastic.
Compostable is allowed.
Compostable is allowed.
Lordship.
So that does not make it a wholesale stoppage.
Regulation. Regulatory.
Day before yesterday, we were served in a conference. We were served food in a plastic plate with plastic cutleries, when we could not use it because it was so thin. Perhaps it was absolutely biodegradable. It was better to use our fingers rather than use the
Lordship.
cutlery.
Lordship. Yes.
So, Mr. Bhatti, you are not totally excluded. You can make changes. You can make changes in the productive mechanism. You can use compostable plastic. You are through. Specific. There is no need of any clarification. And the report that you read, that talks about the way in which the assessment has been made, and collectability is one of the grounds. Littering is another ground. So it has to be a composite assessment, and therefore they say literal, what is it? Litterability. The littering capacity of these cutleries are very, very high. 200 people being fed, which is not a big number. And there'll be around 400 such knives and forks. recyclability and littering capacity, all these go into deciding what has to be stopped immediately, what has to be phased out. So in that case, proportionality theory of yours gets neutralized.
My lord, in table two, your lordship has already gone through table two.
We have seen that table, but now can anybody argue that allow Mr. Bhatti to prepare to manufacture cups which are not biodegradable, which is not made of compostable plastic? Can you say? Can anybody say? It will not only raise eyebrows nationally, but internationally, globally.
And that is that.
You are aware of this.
In fact, Lordship, if I may just point out, Lordship,
Yeah, Lieutenant.
there was a matter before the Honorable Supreme Court from Tamil Nadu, where paper cups were produced and 6% was plastic, whereas 94% was paper. And the Supreme Court has upheld the ban. Supreme Court has upheld.
Because after the paper element in that cup gets it gets
Diluted.
degraded,
Mm.
the plastic sheet remains,
Yes,
and that will choke the drains.
Lordship. I have given a copy of that judgment if you produce.
Where is that?
It was there before. I will give
And
Seed for reasoning. Cellular operators.
Tamil Nadu and Puducherry Paper Cup Manufacturers Association. I'll give a fresh copy.
Case 379. Their affidavit, additional affidavit.
The reasoning would be same.
Your Lordship,
Okay,
we come to
It-
page 12. And page 13.
Because my paper.
Paragraph 43, 44, 45. And 46.
So we are not going to look into this. This is on a different issue altogether.
Lordship,
Yes.
this is
These
19.
Paper
This is not-
Cups Association, they came, they said that if you stop it wholesale, I think you will be promoting tree felling. And therefore they said that with plastic sheet wholesale, that was found to be bad. They say that it was a violation of
Yes, it was
1996.
violation of that.
Now, that's not the case here.
Lordship.
What is the So, Mr. Bhatti, notwithstanding the fact that you argued it very well, proportionality made us think for a while. Because, see, you have to remember that only recycling, capacity to litter, and collectability are not the only things. The important thing is compostability, or the quality of biodegradability. That is missing here. So forget about microns. Use compostable plastics, carry on with your trade vocation. This is a reasonable restriction on your right to trade, right to manufacture. All right, but we must give our reasons.
My lord, according to the information of my client, the whatever we produce, that is biodegradable.
So,
But
this
no,
is clear. You have the exemption. You continue operating your factory, and when they come to question you, should tell them that it is compostable plastic which is being.
But
Then why do you challenge it? Don't challenge it then. if you're using compostable plastic, then I think you are covered under
No,
section
not
3.
compostable,
There is
but
no prohibition.
Biodegradable is compostable. That's the meaning. Biodegradable is compostable. Let's see, let's check up again.
It's in the biodegradable plastic. And it's important.
AC lordship.
Oh, okay, good. Plastics other than compostable, oh, sorry, which undergoes degradation by, and it says biodegradable plastics and compostable also. Section 3 says. The provisions of sub-rule 2B shall not apply to commodities made of compostable plastic and biodegradable plastic. That also has been added with effect from 2022. Then you don't have a challenge. Don't question this then. You're not required to write it. Don't question this. Then where is the, then we will give you a 1-page order that you are not covered by this rules.
yes.
Okay.
But-
Take that. Yeah. Take that. We have heard Mr. O.P. Bhatti. We have heard Mr. O.P. Bhatti, learned advocate for the petitioners, and Mr. R.K.T. Chaudhary for the Union of India. This writ petition has been filed by 8 manufacturers of disposable plastic items such as plates, cups, glasses, cutlery, straws, trays, and similar single-use plastic products. They claim to have established their industrial units after complying with state industrial policies, obtaining incentives, tax exemptions, and necessary permissions from the state pollution control boards. The challenge in this petition is to rule 4(2)(b), 4, then 2 within brackets, then small b within brackets, 4(2)(b) of the Plastic Management Rules 2016 as amended within bracket, notified by the Ministry of Environment, Forests and Climate Change on August 12, 2021. Next pad. This rule prohibits the manufacture, import, stocking, distribution, sale, and use of a specific single-use plastic commodities, including plates, cups, glasses, cutlery, straws, etc. Etc. The contention of the petitioners is that this absolute ban is arbitrary and discriminatory, as their products are recyclable, which could be managed through existing waste systems. Yet, the rule singles them out while allowing other similar or even non-recyclable plastics. Their concern is that this ban will render their investments obsolete, would lead to their financial ruin, forced plant closures, which ultimately would result in job losses for skilled and unskilled workers without providing any transitional support or alternatives. Mr. Bhatti, while addressing us, also laid great stress on the disproportionality of the rule in question by demonstrating that on the scores of littering capacity, collectability, and recyclability, their product, the products of the petitioners, the manufactured products of the petitioners would not would not fall in the category of banned plastic, banned single-use plastic. For the sake of completeness, we deem it appropriate to extract section 4 of Rule 4 of the Plastic Waste Management Rules 2016 in its entirety. A bare reading of the rule would indicate that plates, cups, glasses, cutlery such as forks, spoons, knives, straw, trays, wrapping or packing films around sweet boxes, invitation cards, cigarette packets, plastic or PVC banners less than 100 microns, stirrers, are prohibited from being manufactured, imported, stocked, distributed, sold, or made use of. However, subsection 3 of Rule 4 further clarifies that the provisions of Subrule 2B, referred to above, shall not apply to commodities made of compostable plastics and biodegradable plastics. Next, compostable plastics, according to the dictionary of the rules, mean plastic that undergoes degradation by biological process during composting to yield CO2, water, inorganic compounds, and biomass at a rate consistent with other known compostable materials, excluding conventional petro-based plastics, and does not leave visible, distinguishable, or toxic residue. Biodegradable plastics means plastics other than compostable plastics, which undergoes degradation by biological processes under ambient environment, bracket terrestrial or in water, bracket close, conditions, comma, without leaving any microplastics or visible or distinguishable or toxic residue which has adverse environment impacts, comma, adhering to the laid down standards of Bureau of Indian Standards and certified by the Central Pollution Control Board. The restriction thus on the manufacture of cups, glasses, cutlery, etc. is not absolute. And the only restriction which has been imposed under the rules for, for ecological preservation is that the plastics used in such production / manufacture should be compostable or or biodegradable. This reasonable restriction is absolutely permissible and cannot be said to violate any fundamental right of the petitioner for carrying out his trade, vocation, etc. After some arguments on the query made by the court, Mr. Bhatti, on instructions, submitted that the product manufactured by the petitioners are only of compostable and biodegradable plastics.
The
Are of only biodegradable plastics, compostable. In that view of the matter, the restriction imposed under Rule 4(2)(b) would not apply to the products of the petitioners. Thus, the grounds raised in the petition remain only academic, which is not necessarily required to be decided. Since the petitioners are not affected by the Plastic Waste Management Rules 2016, we close this petition. We close this petition for the rules not having any deleterious effect on the business of the petition. The writ petition stands disposed of the court.
But
We have not asked you to withdraw this also.
that's okay.
10 and 11. Item 10 and 11.
Yes, Mr. Mishra,
My lord,
good to see you in person. All this while you had been appearing virtually.
my lord. My lord,
And you can address us while sitting.
my lord.
You can sit down and address.
No, so long I can, I will. My lord, I'll stand.
From our side, we have offered.
My lord, that is very kind of you, Lord. Very kind.
Yes, yes.
My lord, kindly see your lordship's order dated 22nd of July, 2025. The last portion.
22nd of July.
July.
It's 20. Yeah, yes.
Item 11.
Item 11.
All right, bear with.
Yes, Mr. Commissioner.
Well, the affidavits have been filed. One affidavit is filed by the respondent number 5. And the another affidavit is in reply to the additional affidavit filed by the petitioner, was filed by respondent number 2 to 4. I'll refer to these affidavits while I proceed with my argument.
Can we have page number?
My lord, the AO by respondent number 5 is at page 140. 140 to 150.
Yes.
I'll take there are only 2 paragraphs. Paragraph 6 and 7. I'll take your lordship when I reach that stage. The another is affidavit in reply to the additional affidavit filed by us is page 122. Isn't it? 122. Date of filing cycle.
Yeah.
Date of filing.
Yes. Which are you referring?
My lord.
Which affidavit are you referring now?
No, I'm not
At page
referring any affidavit. First, I will refer to the impugned SOP and the rules first. My lord, may kindly come to page 64. This is the beginning of the ordeal of the public, if I may say it so. Page 64 of the paper book. The lordship got L place. I'm directed to refer to this ministry's letter dated so and so, and to say that this ministry has received a number of representation about mechanism to be adopted by traffic transport related enforcement agencies to validate or impound documents in case the citizen produces document in an electronic form. In view of above, standard operating procedure are annexed may be adopted for ensuring compliance with the provision of section Rule 139 of the Central Motor Vehicles Rule 1989. Now your lordship will kindly come to page 68, the relevant, that is generating challan, clause 4.3. Page 68.
Yeah.
Your lordship, I'll take your lordship to the relevant clause, clause 6 and 7, Roman 6 and 7. Roman 6 is, my lord, if a challan is pending or has not been disposed of, then all transactions involving the vehicle, that is NOC, tax, etc., for driving license, that is renewal, address change, etc., are not permitted and are reflected in the traffic enforcement agency across India. 7. Violators are required to compound, kindly mark it. Violators are required to compound and close pending cases as early as possible to start or avail services like tax payment, NOC, fitness, etc. This is forced compounding. The meaning of compounding, and my lord, I'm surprised, respondent number 1, the government of Union of India, my lord, has repeated in its affidavit in opposition that we have the power to compound the offenses. But compounding is also always two-way traffic. It can't be, my lord, one way. And
Except 324, when the government seeks to withdraw the prosecution.
that is, yes, that your lordship is absolutely correct. That also is subject to, my lord, the court. Otherwise, your lordship knows. In UP, some cases were sought to be withdrawn, it was rejected. The judge is transferred. Recently, my lord, the session judge. Now, your lordship will kindly come to page 54 of my compilation, if your lordship, we have given or not? I'm sorry, your lord, please. No, aste. Compilation. Compilation itu. Aste niki. Aku tu bilang boleh. Before. My lord, page 54. Composition at page 55. Mutual settlement or agreement between two or more persons as to debt. Compound. Compound is to settle amicably, compromise, to agree for a consideration, not to prosecute. In the SOP, they say that we are required to compound if we want the services to start and avail. I'm saying, well, from right one, maybe I was not able to make myself clear right from beginning that this compounding is nothing, but it's a camouflage to levy forcible fine. And I will show from the receipt that they are giving when I go to that. Now, my lord, I'll take your lordships to the affidavit in opposition filed by respondent number 1, page 86.
No, it. Page number?
Page number, my lord, relevant page will be 88, page 4. It starts with 86, my lord, paragraph, page 86.
Yeah.
Section 200 of the Motor Vehicles Act 1988 empowers the state to compound an offense either before or after institution of the prosecution for such amount as may be notified by the state government. Further, Section 200 provides that in case of compounding of offenses, page 89.
Yes. Perhaps we are not on the same page. It talks about 200, section 200.
Yes. So 200 is Section 200 of the Motor Vehicles Act is composition, compounding.
That's right. It has been quoted. Are you on the same page?
Yes,
Page 89.
89.
Oh.
Section 200
Hmm.
of the Motor Vehicles Act 1988 empowers the state government to compound an offense
Hmm.
either before or after institution of the prosecution for such amount as may be notified by the state government. Further, Section 200 provides that in case of compounding of offenses, if the person is in custody, he shall be discharged and no further proceeding shall take place. I leave it to your lordship whether such things can be permitted. I'm not going to argue anything on this. Now, my lord, I'll place before your lordship rule 160, what I've
Just. Yes.
Now, my lord, this was challenged to SOP. Then the second challenge is Central Motor Vehicles 11th Amendment Rules 2020. This your lordship will get at page 52. The relevant will be at page 53. And I have given from, my lord, the my lord, we have annexed the gadget notification, so this will be an authentic one, maybe more than the books. It starts with page 52, my lord.
Yes.
That is the gadget. Next page, your lordship will come to page 53. Short title and commencement. These rules may be called the Central Motor Vehicles 11th Amendment Rules 2020 and came into force from 1st October 2020. Now your lordship may go to page 55. 55. The relevant rule that I'm placing at this stage is 167.5, which your lordship will get at page 56.
Yes.
The challan issued under sub-rule 1 and or 2 shall be disposed of within 90 days from the date of issuance of challan in physical or electronic form, except in case of offences instituted for prosecution by a court. Suppose, my lord, they send it to the court, then they will not impose any restrictions. Now, my lord, your lordship will come to sub-rule 7, 167.7, the same page. If a challan is due beyond the time period specified in sub-rule 5, except in cases of offences instituted for prosecution by a court, then application with respect to the license of offender or registration of motor vehicles, as the case may be, mentioned in the challan shall not be processed by the licensing authority or registered authority, as the case may be, except application relating to permit fitness to access motor vehicle. So once the challan is uploaded, all services get stopped. We have to pay. This is forcible compounding. And they say so. It's not that I'm only making my submission. They say so because your lordship's order of 22nd July perhaps made them file those affidavit in opposition, admitting what is the current position. My lord will kindly see affidavit in opposition filed by respondent number 5, who is Inspector General Traffic. Page 140. This was filed on.
Yes.
My lord, the affidavit in opposition starts at page 140. The relevant two paragraphs I will refer is paragraph 6 and 7 at page 144. 144. Well, the paragraph is little longer, but I want to place the entire paragraph because this lay bears what they are doing. That by following the aforesaid statutory provision of law prescribed under the Central Motor Vehicles Rule 1989, the officials of the department issue a challan through system or e-challan facility, physical or electronic form, to a person who violates the provision of the Act. There are three options for enforcing through e-challan. They are with payment. This includes payment by cash or card on the spot. Without payment. This involves payment by way of link sent to the registered mobile number of the owner of the vehicle. Third option is sent to the court. This is only option where the case is not sent to the virtual
The
court.
case is sent to the virtual.
Yes, virtual court, nothing happens, my lord. We just
Like
get
the same thing.
the come and pay. That's the thing. The procedure adopted in serial number 1. My lord, actually, I'm not concerned with serial number 1. If your lordship say, I will avoid it because we have not made payment. I come to the last para, my lord. Procedure adopted in serial number 2. Without payment. This involves payment by way of link sent to the registered mobile number of the owner of the vehicle by giving 90 days period for deposition of fine. So these 90 days is for the owners to pay. In this process, the authorized police officer will take a photograph of the offending vehicle in his mobile in presence of witness, and thereafter he recorded chronologically in portal, a software developed by the Government of India through National Informatics Center on regular basis for access by enforcement officer. Immediately after uploading the same, a system generated SMS would be forwarded to the owner of the vehicle through his registered mobile number along with the link for payment, so that owner may make payment within 90 days. Moreover, before the expiry of a stipulated period of 90 days, a system-generated reminder message again forwarded to the registered mobile number of the vehicle of the owner for payment of pending challan. After making payment, the payee will get a system-generated money receipt. Against this payment, pending challan would be deleted by the system itself as per its setting. And if the owner wants to delete his pending challan from NIC system urgently, in that case, he may approach before the office of the concerned SSP, DCP, Guwahati, making application by enclosing valid payment receipt. On being received such application for deleting the name of the offender, the owner the department will manually delete the same from the system. Then this is not required. Owners is not, phone number is not registered. Then the third parameter, the procedure adopted in serial number 3. This is important for us. Cases sending to the concerned jurisdictional court at page 146.
Yeah.
This is the only option where cases can be sent to the virtual court by the police. MV challans cases are initially transferred to the virtual court by the police. If the fine remains unpaid after 90 days period, the system automatically reverts the case to the regular court, displaying the status transferred to the court. So if it's a public interest litigation, I should not give at least my example I'm appearing, but I can give my lord here. There's no way. I have stopped driving long back. Now, though, I have written to the RTO that I'm surrendering. I will not even take the driving license because I cannot drive. So they challan the vehicle. Once was for speeding after dropping some of my children, my lord, and the driver was coming alone. Maybe it was, and the other was for wrong parking or unauthorized parking. So I thought, well, let me at least, I don't want to keep anything on I didn't want to get into litigation. So one I paid. The other I was told that it is already sent to the court, that unauthorized parking. So I sent my junior to the court. Now court, there is a huge line. It is difficult to get the case registered immediately. You have to wait. Until then, you cannot avail these services. It remains like that. Anyway, some ingenious methods were developed and I had to pay only 500 rupees in place of 2,000. And I'll come to that. Where do we go? Because 179, I can show, my lord, will not apply to unauthorized parking. What applies is 177, read with section 116 and 119 of the Motor Vehicles Act. But where do we go? There is no place, so we paid. So, my lord, no, my junior saying, dikhana hai kya? Main nahi dikhana hai, rakho. I'm reading the second paragraph. So, my lord, after 90 days only it goes to the court. And we find it difficult even to get our case listed and then pay the fine. In case where, the last para I'm reading, in cases
So
where,
they leave you with no option.
my lord,
So according to you, they leave you with no option.
No option.
Compound it, pay the fine,
Yes.
whether you are guilty or not.
yes, absolutely. Now, in cases where non-FIR MB challans are issued, the challans are sent to the respective courts through concerned so-and-so, so-and-so. Now I'll take your lordships to 7 at page 148. The traffic department does not send any physical copy of the challan to the concerned jurisdictional court, except uploaded in the designated website. All e-challans are contemporaneously not sent to the court unless the offenders dispute the challan and opts for court hearing. Offense mandates a court appearance, that is drunken driving, dangerous driving, etc. The challan remains unpaid beyond permissible limit, triggering legal proceeding. So it will go only after 90 days. Till 90 days, we will not avail any service, and either you compound or now the last portion of that paragraph 7 for at page 149. For realization of fine beyond 90 days, if a challan is not paid within prescribed 90 days period, the following process typically applies. Unpaid challans are flagged as pending or default in aforementioned enforcement database An automated reminder may be sent to the registered owner depending on the system in use. If the owner claim non-receipt of the challan, they can verify the challan status using Parivartan portal state so and so. Upon non-payment, the case may forward it to the jurisdictional court or the magistrate. Now, my lord, I would, my lord, like to show your lordship at this stage at page 74, if my lord will kindly come to. Sorry, page 71, 70, my lord. Page 70. Page 70. Your lordship will see towards the bottom after the 1791 disobedience of order of authority. Lordship, or below the block. Then your lordship will write, see, remark. Remark is unauthorized parking. Unauthorized parking. Now, my lord will kindly come to page 74. My lord, from top, if it's not very clear, your lordship will see from the top, Transport Department, Assam. Enforcement branch. Below that, your lordship will see on the right side, e-challan compounding fee deposit receipt. Now,
119.
my lord, the clear copy of not this but other I have enclosed is at page 119.
It's clear, Mr.
Fine.
This is clear.
Otherwise, 119 is very clear. It's like,
Okay, 74 also.
Okay.
We can, not clear, but we can see it.
yes. Therefore, my lord, for my side,
Challan, Dashman, Shulk,
what
Jama Rasid, e-challan, compounding fee deposit
receipt.
receipt.
Now, if your lordship just turn to 119. On top, my lord will see e-challan compounding fee. This is for not wearing helmet. E-challan compounding fee. Then, my lord, your lordship is at page 71 and 74, your lordship has seen. Your lordship kindly come to page 72. I'm sorry, my lord. Since I'm here, I will argue this point also. 183, my lord has seen. Now, 183, this challan was, my lord, is dated 3/11/2023. Isn't it? And payment. And the payment date, if your lordship will see at page 74, 1/7/2024. It comes to, my lord, 7 months, 28 days calculated. The lordship is aware of section 468 of the RPC. After 6 months, nothing can be done. If an offense is punishable, it's fine. Time barred, but compounding can be done. Nobody will stop me from going and paying. No, I want to pay. This is the state of affair. This is how we are being made to pay. Another thing is, if your lordship will kindly take section 209 of the Act, Motor Vehicles Act 1980, there.
Yes, sir.
209, well, there is a restriction on punishment under section 183. Restriction on conviction. No person prosecuted for an offense punishable under 183 or section 184. I'm sorry, my lord. No person prosecuted for an offense punishable under section 183 or 184 shall be convicted unless he was warned at the time of offense was committed that the question of prosecuting him would be taken into consideration. Next, within 14 days from the commission of the offense, a notice specifying the nature of offense and the time and place where it is alleged to have been committed was served on and sentenced by registered post and sent by registered post or the person registered as the owner of the vehicle at the time of commission of the offense. Within 28 days of the commission of the offense, a summons for the offense was served on him. Provided nothing in this section shall apply, where court is satisfied that failure to serve the notice or summons referred to it is not relevant at present. My lord, therefore, a notice of 14 days is a must for launching a prosecution and punishing. But here, pay the compounding fee, otherwise your license will not be renewed. Your RC will not be transferred or renewed. Now imagine, my lord, of a condition of a driver. He is a paid driver, he is driving. His license is expired. He cannot get it renewed till the owner pays. An owner refused to pay. I'll take another driver. Why should you pay? Just consider that. It's inhuman, my lord, what they are doing. And there are reasons that we have got such, my lord, I'll say good or clear or truthful AO. Because the officers themselves are suffering there with their private cars. When the children go, they have to undergo the same thing. It will come, accused. I received DK Mishra accused. Is there? Whoever is there, private car is there, you are accused. Compound the offense if you want this to be renewed. This is what is happening. Now, my lord, now let me just place, my lord, 1791. I'll complete my argument. 179. 1791 is punishable with only fine. 1792 is punishable with imprisonment. 179, if your lordship got, I'll place it.
Yeah.
Disobedience of order, obstruction, and refusal of information. Whoever willfully disobeys any direction lawfully given by any person or authority empowered under this act to give such directions or obstruct any person or authority in discharge of any function which such person or authority is required or empowered under this act to discharge shall, if no other penalty is provided for the offense, be punishable with offense which may extend to 2,000 rupees. So there is, I have shown, my lord, page 70 71, my lord. Your lordship, kindly turn to page 71.
It's there.
179. Now, I asked a question to myself, which order direction I have willfully disobeyed? Where I have obstructed? Nothing is there in the challan. And for unauthorized parking, the relevant section will be, my lord may turn to page, section 116. Section 116 read with 119. I'll place 1A and B. Lordship got me. The state government or any authority authorized in this behalf by the state government may cause or permit traffic signs to be placed or erected at any place, public place, for the purpose of bringing to the public notice any speed limit fixed under subsection 2 of section 112, or any prohibition, restrictions imposed under section 115, or generally for the purpose of regulating motor vehicle traffic. B, state government or any authority authorized in this behalf by the state government may, by notification in the official gazette, by erection at suitable places of appropriate traffic sign referred to in part A of the schedule, designate certain roads as main roads for the purpose of driving regulation made by the central government. Now, if my lord will kindly see the schedule, first schedule attached to that, this act. My lord, if we are having same 2025.
This is 2024. Then schedule would be there.
My lord, page number 168 here in this case, 25, 33.
Yes.
My lord, this is first schedule part A. And your lordship will kindly go to page 174.
Page matching.
This is, my lord, size, this is
Sign.
sign M19. The sign number is M19 at page 174. So therefore, we get, my lord, every day no parking sign. And then, my lord, kindly come to page 119, section 119. Section 119. Duty to obey traffic sign.
Yes.
Every driver of a motor vehicle shall drive the vehicle in conformity with any indication given by mandatory traffic sign and in conformity with the driving regulation made by the central government, and shall comply with all directions given to him by any police officer for the time being engaged in regulation of traffic in any public place. In this section, mandatory traffic signs means traffic signs included in part A first schedule, or any traffic sign of similar form, then rest is not relevant. And violation of this, it's duty to follow. If we violate, then, my lord, the person can be prosecuted under 177. Your lordship will see 177. General provision for punishment of offences. Whoever contravenes any provision of this act or any rules, regulations, or notification made thereunder shall, if no penalty is provided for offence, be punishable for the first offence with a fine which may extend to 500 rupees, and for the second or subsequent offences with a fine which may extend to 1,500 rupees. Unlike 179, there was two. According to my submission, my lord, for unauthorized parking, these are the provisions. Because 179 contains violation, willful violation of a direction, obstruction. So that should be mentioned in the challan. Nothing is there. My lord, now I will come, my lord, to I'll take two decisions I'll cite with your lordship. Just to show that even if offenses are punishable with only fine, it is the duty of the prosecution to prove it. The first case I will show is the state of UP versus Bansraj. I have annexed in the at page 156. Compilation.
Compilation.
Yes. Funny.
Yes.
My lord, here the punishment was under section 123 of the Motor Vehicles Act 1939. Now, if your lordship, if I can take your lordships through the Motor Vehicles Act. I have an next, my lord, in the compilation. Before I take your lordship to the your lordship will get page 168. I have annexed Motor Vehicles Act. At page 160, I have annexed the relevant 123 will be 168. Whoever drives a motor vehicle or causes or allows a motor vehicles to be used or lets out a motor vehicle for use in contravention of the provision of subsection 1 of section 42 shall be punishable for first offense, which may extend to ₹500, and for the subsequent offense, if committed within 3 years of commission of a previous similar offense, a fine which shall not be less than ₹100 and may extend to ₹1,000. So it was only punishable with fine. Now, my lord, here the driver, Bansraj, he was sentenced to pay a fine of ₹200 under section 123. It's a small fact. If your lordship permit me, I'll just place it at 156. A small fact. Criminal Appeal 115 of 1956. The respondent Bansraj, driver of a public carrier, which he was not the owner, was found carrying 23 passengers instead of 6 allowed under the condition of permit granted to the owner. The vehicle was checked by the head constable who, on counting the number of passengers, found them to be 23. Bansraj, respondent, was prosecuted under section 42, read with section 123 of the Motor Vehicles Act. Bansraj, respondent, pleaded not guilty, as stated that only 6 passengers were being carried. He was tried summarily by first-class magistrate Gorakhpur and found guilty under section 123 of the Act and sentenced to pay a fine of ₹200. In default, 3 months rigorous imprisonment. He went in revision to session judge, and there it was contended that he was only a driver, therefore could not have been convicted under section 123 of the Act. The learned judge accepted the contention, and being of the opinion that a mere driver could not be so convicted, he recommended the case to the High Court. Well, earlier, there was a provision under 1898 CRPC for making a the word used is report to the High Court. I have that. Okay? I can place that.
We are aware of that.
He recommended the case to the High Court under section 438 of the criminal procedure. The matter came up as criminal reference 359 of 52 before Justice Mukherjee, who referred it to division bench and was heard by Desai and Upadhyay. The interpretation of High Court put on section 42(1) was that under section it was the owner alone who was interdicted from using or permitting to use the vehicle save in accordance with the conditions of permit. And therefore, if the vehicle was used against the condition of permit, no one else, including the driver, could be guilty of section 123 of the, so it was set aside. Then the matter went to Supreme Court. State of UP took the matter. And then, my lord, the matter was remanded and said they will prosecute both. So all that I'm trying to place before your lordship is that even if an offense is punishable with only fine, all rights are intact. All rights are intact. Similarly, there is another case, that's very important, interesting case. There was one Major Anand in Jammu and Kashmir. He was driving a scooter, but he was not in the uniform, in his uniform. Now, he was prosecuted under section 86 and was punished under section 112. It's same, my lord, as 177, earlier 112. Then he was, my lord, but the magistrate imposed a fine of ₹10 only on him, or in default 2 days simple imprisonment. The matter went to the High Court. So he raised 2 points. Number one, there is choice of jurisdiction. If lordship remember, I also don't know whether my memory is with me. Earlier, my lord, there was a provision under CRPC giving an option to the military persons to opt for court-martial or the regular. I think it was 475, I remember that. But I'm sure your lordships are aware. So first he says, he raised that point that I had an option, that option was not given. That was discussed by the High Court and they said, no, this option is not available to you. But on the second count, they say that there is an allegation that person, police, a man in uniform, a police in uniform stopped you and did not stop. On that, the High Court said it could not be proved that the man was in uniform. He was acquitted. That is at page 153. All that I'm saying, my lord, these are merely, all right, 2,000 fine, but cannot take away our right. The right is there. If we compound on your own, it's a different, but you are forcing us to compound. You are not sending the case to the court and you are stopping all the services. So therefore, in my humble submission, my lord, these are absolutely...
So what you have said has substance, but see the other side of it. We have these statistics because for the purposes of setting up digital courts, e-courts, the first experiment was with transport, these challan cases. Distance courts, virtual courts. Now 99.9% of the people would go for compounding. So they say this issue was raised in other states also. With respect to forcible compounding, the other party is not agreeable. He wants to contest.
Yeah.
He is not guilty. Therefore, whatever, summary decision or whatever. He said that, well, that option you have, but then we give you a window. 2 things. One, that it takes time, especially the system is not so robust that the accused will be intimated about it. And number 2, he may find it difficult to garner that money because traffic payment is only 2,000. These days, I don't know, for pollution, non-updated pollution certificate, you have 5,000 for something which is 10,000.
Yes,
But now the amount is big.
Yes.
So they say that they will take some time and therefore do it. Now, in the meantime, what had happened was that these pollution control board certificates also were not being given if the challan
That your lordship has passed orders.
that was clear. That
Yes.
was that
Yes.
was now. In
Yes.
many places, this is being done.
Yes.
Now, the other side is this, that no, they are not forcing you to compound. Something which if you want to compound, please come. We give you 90 days time.
No, but then my services are stopped.
Well, that
you-
SOP is only because this segregation
Yes.
would not per se be illegal, but the spiraling effect of it because of the 90 days, you would say that no, don't wait for 90 days. In that case, sir, the difficulty is that we are trying to manage it because of the huge number. We are trying to manage it by electronic mode. And since it is electronic mode, some time has to be given. I mean, that does not answer your objection, but these are the practical realities of life where we have given 90 days, we have put our imprimatur on that, only for the reason that it be done, but going to court, engaging a lawyer, appearing before the magistrate, trying to so, and you don't have always DiCaprio as a judge who would see the video and would be more than indulgent. The man is dead, if you know.
My lord, in fact, the impression is, or that challan has come, you have to pay. That is, everybody, as your lordship has said, 90% they compound.
99 days. We have these statistics.
Why force?
No.
Why this? We get from the court, we will go. And because courts cannot be managed, we cannot be punished. That is not our problem.
This is a very big logic. You may realize that.
That is not our problem. And my lord, kindly see, even that day I was referring to common causes case. There was an outer limit that was of course set aside, my lord, by 7 judges bench. But they say that Article 21 is still you have, and if there is an inordinate delay, the case can be quashed. Accused can be released. But what happens if the delay is caused because of the accused? Then you cannot get the benefit. Now here what is happening is delay is not our part. We get the notice, my lord, your lordship is absolutely correct. Nobody will contest. They'll prefer to go and pay 500 rupees. But here, there is a limit, my lord. So many photographs and then you receive it. And another thing, my lord, your lordship will see what pinches us is, your lordship will kindly come
You have made your point. So, Mr. Mishra, you say that this SOP needs change.
SOP as well as, my lord, even 167, 5 and 7 says it has 90 days for making payment. 90 days for making payment. My lord, just two things. Let me just place. After that, my lord, I'll leave it to your lordship. I have filed also, my lord,
Yes,
a written thing. So I'll leave it at that. My lord, just two things I want to place. My lord, your lordship will kindly come to page 45
Of the brief.
of the paper book, my lord. Of paper book, my lord. Paper book. Yes, sir. My lord, 56, 55. Any police officer in uniform, last part, my lord, 167. 1.
Yes.
Any police officer in uniform or any other officer authorized by the state government in this behalf shall issue a challan through system of e-challan facility, physically or electronic form, to a person acting in violation of the provision of the Act. So it is to the violator. Your lordship will see 177 or whatever section, it is to the violator only. Only they can be punished. Now your lordship will kindly come to, my lord, 63. '63. 7. 167A7. Challan under sub-rule 1 and 2 shall be issued in the name of registered owner of the vehicle and must be accompanied with notice of offences in electronic form. So it will go to the registered owner. Police will not take even trouble to ring up the owner and ask who was driving. They will issue notice, make him accused. You are accused. And
these are the drawbacks of digital courts, electronic messaging. These are the problems. How can it be?
no, the problem lies with the man.
See, the difficulty, Mr. Mishra, I can understand. I mean, your logic is absolutely indisputable. But then look at the practicality of it. A driver coming from some remote area in Bihar, he he finds a engagement in Assam. He starts driving Mr. Mishra's car.
Yeah.
Now, how would he be identified?
My lord, first of all,
The
whenever,
identification is only through the vehicle number.
no, whenever anybody keeps a driver, if he's outside, he has to get it. Always do it, get it verified. Police.
No, you
from
do
police.
verify, but do you
And-
upload that information with the transport department?
My
You,
lord,
you don't do it.
what-
It's not
whatever-
required.
Whatever maybe I'm talking of Guwahati, this is happening in Guwahati. I received DK Mishra accused.
No,
I
no,
received that summon.
this
It's
is
pinches.
everywhere, Mr. Mishra. The identification is only by the registration of the vehicle and registration of the vehicle. You're right, accused. A person has to be a violator. And because you own a car, you have not violated somebody, you have given it to a licensed driver. These aspects do come back because of the pettiness. See, there is
It has not only stopped there. Your lordship will see 10. 167, 8, 10 on the same page. Kindly see.
you see, there is, of course, it is not used in this parlance, but then there is a Latin phrase which says, de minimis non curat lex.
Well,
For petty things, law should not be invoked.
Article 21 will not forbid that we can
that's-
invoke. My lord, kindly let me just read this 10.
And the opposite is also correct. And the opposite of is also true. Whether it is a theft of a loaf or theft of a watch,
Yes.
the offense is completed.
Yes.
That it goes like this: necessitatis
Yes.
inducit privilegium coad jura privet.
Your lordship has, I remember, my lord, there was a book, Not a Penny Less, Not a Penny More. Your lordship has. This was about a doctor in Gestapo who did all this and he was hiding and he had changed his identity. Somebody identified him and wrote an article and he filed a libel suit against him in America.
Sure.
So in the everything became very clear to the judge that he is the same person, but there was no legal evidence available. So he says, I award you a penny, not a penny more, not a penny less. That was. Well, 10, let me just place. This will be very amusing. If the owner of the vehicle is not driving the vehicle at the time of offense, he may claim innocence before the police officer or any officer authorized by the state government by providing appropriate proof that he was not driver at the time of offense or that any other person was driving the vehicle.
And in that case, what will happen?
Then he will change the name. So I have to go before sub-inspector and say, साहब, हम नहीं चला रहे थे. ये ड्राइवर का लाइसेंस है, ये आधार है, वो चला रहा है. Then he will think, okay, whether you are innocent or not, that I will decide. So an accuser is made an adjudicator. This is what the rule is. And this is man-made. My lord will remember Dr. Ambedkar's statement in the parliament, and which I'm seeing now. He said, if this constitution fails, it will not fail because the constitution is bad, but the man was vile. Let me see, my lord, I forget things. Later on, I remember how this I did not.
No, you have said everything.
No,
You have
another,
just
my lord,
both pictures.
one universal declaration of human right. That, because we may use it. My lord, stopping all services the moment challan is loaded is in gross violation of fundamental principles of presumption of innocence, which has a direct link, my lord, to the right against self-discrimination. There are two decisions on the point. One, it's Selvi, your lordship knows that polygraph test 2010. I need not, my lord. I'll just place only declaration. I'll place declaration has been approved by the Supreme Court in Satyendra Kumar Until case. My lord will know that bail matter. Okay. Page 195, my lord, of the compilation. Article 11. Article 11 is the last para of at page 196. Everyone charged with a penal offense has right to be presumed innocent until guilty in accordance with law in a public trial at which he had all guaranteed necessity for his defense. No one shall be held guilty by any penal offense on account of any act or omission, which of course didn't constitute offense. Now, this was, my lord, in Satyendra Kumar until case, as well as your lordship will kindly turn just few paragraphs, one paragraph I will show, few lines. Page 200 of this, if your lordship. Oh, I'm sorry. It's
200 is Selvi.
200, Selvi, madam. That 87 at page 201, last three lines. At page 201.
Yes.
The guarantee of presumption of innocence bears direct link to the right against self-incrimination, since compelling accused person to testify would place the burden of proving innocence on the accused instead of requiring prosecution to prove the guilt. Then same thing, this Until's case, their universal declaration, which I just placed, was discussed in paragraph 14 and 15. With this, I will conclude, my lord. My lord, that relevant is at page 79, paragraph 14 and 15. Innocence of a person accused of an offense is presumed through a legal fiction, placing the onus on the prosecution to prove the guilt before the court. Thus, it is for that agency to satisfy the court that arrest made was warranted and enlarged on bail is to be denied. Presumption of innocence has been acknowledged throughout the world. Article 14.2 of the International Covenant on Civil and Political Rights 1966 and Article 11 of the Universal Declaration of Human Rights 1948 acknowledges the presumption of innocence as a cardinal principle of law until individual is proven guilty. So that has an approval of the Supreme Court. My lord, I have my lord, I have all given in writing. I know, my lord, one thing, because the first day when I moved this petition, I have an experience and I'll share with you. Justice Suman Syam was sitting with the Chief Justice. He says, Mr. Mishra, did you see the video? You go and see. We are part of it. This virtual courts that time. So that difficulty is there, but then this side also there is difficulty. Now, my lord may strike the balance.
But it was a pleasure to hear you, Mr. Mishra.
My lord, your
It
lord.
was a great pleasure. Mr. Chaudhary, you would conclude your arguments in 5 minutes, maximum of 10 minutes, the outer limit like 90 days. We come back after lunch.
My lord,
Mr. Mishra, you need not be.
my lord, I'm all right.
Miles, I appear in item number 10, my lord, and we adopt the submissions of the learned Singh.
All right. Give your appearance slip.
We have already.
May I please, your lordship? Lordship, my senior has taken your lordship through the SOP and the Rule 167 and 167A. Now, the SOP is of 2018, perhaps with the coming of the rules in 2021. That issue goes.
What
Because
happened? I didn't get you.
the SOPs, which my
Is of 2018.
2018,
Then?
after that,
Uh.
the amendment came in 2021. So perhaps we have to look into the amended provisions of the rules, Lordship. So I will not take your Lordship to the SOP, to the rule. Now, if your Lordship will come to 167 for a moment, Lordship. That your Lordship will find at page 55 of the writ petition.
PIL number 46.
PL number 46, Lordship.
Page.
Page 55, it starts at page 53, 52.
Yeah.
I'm taking your Lordship to page 55. That is 167.
Hmm.
And my senior is agreed by the issue of challan, which is sub-rule 5, 6, 7. Now, if your Lordship will see 167.5, challans issued under rules 1 and 2, 1 or 2, sub-rules 1 or 2 shall be disposed of within 90 days from the issuance of the challan in physical or electronic form, except in cases of offense instituted for prosecution by a court. We are not on prosecution by court. If a challan is due beyond the time period specified in sub-rule 5, at least one additional notice for payment may be sent through electronic means of communication authorized by the central government or state government, or by way of call to the registered mobile number of a person who violates the provisions of the Act. If a challan is due beyond the time specified in sub-rule 5, except in case of offences instituted by prosecution of court, then the applications with respect of license of offender or registration of a motor vehicle, as the case may be mentioned in the challan, shall not be processed by the licensing authority or registering authority, as the case may be, except application relating to permit, fitness, taxes of motor vehicles.
Yeah.
Now, Lordship will see there is an outer limit of 90 days. If the challan is due beyond the period of 90 days, a reminder has to be given under sub-rule 6. And what are the things? My senior has not taken your Lordship to the attachments, what are to be there with the challan, the proof. If I may take your Lordship to the rule 167A. That your Lordship will find at page. The relevant page would be page 63, that is 167A6, I'll be referring. Lordship has got page 63 of the writ petition.
Yeah.
Now, it is not only that the challan is sent. 6, all challans issued under rules 167 in electronic form using auto generation of challans through the electronic monitoring and enforcement system shall be accompanied with the following information: clear photographic evidence highlighting the offense and the license plate of the vehicle, measurement from the electronic enforcement device, date and time and place of the offense, notice specifying the provisions of the Act that has been violated, certificate as per subsection 4 of section 65 of the Indian Evidence Act, which identifies the electronic record and describes the manner in which it was produced, gives such particulars of any device involving the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer, signed by the officer authorized.
I've seen that.
No,
And last is 10. In case the owner is not driving, he can produce proof.
yes, now, from the materials what has been placed before your lordship, that is NHS 6, page 70, then whether all the parameters which have been given under sub-rule 6 have been met. Because once a
But
person,
Mr. Chaudhary, why are you dwelling
I-
on that? The question is that he has argued a slender point. He says that, 60 days time, till such time the challan is discharged, other clearances will not be given, your license will not be renewed and all that. He says that this amounts to a forced compounding or forced composition till 90 days.
I'll be coming to that.
Only that.
Yes, yes, I'll be coming. to-
Yes, so
Yes.
this is it.
Now, from what I
You
understand.
have a ready-made answer.
No, I have. Lordship, from what I understand from my senior's argument placed before this court is, it is not exactly the provisions of the rules. It is the enforcement of the rules
Workability of it.
which is bothering. Now, if I cannot say on the basis of my affidavit, but my understanding of the issue would be, Lordship, if a challan is issued, today a challan is issued, now why wait for 90 days? If it is immediately
No,
sent,
that is.
sent to
that
the
is there.
court,
See, he gets a challan today.
yes,
Now, tomorrow he decides to contest it.
that
He
is,
says that, no, I am not guilty. Therefore, he'll have to wait for 90 days till your challan is transmitted to the court.
no, that is the practice that is going on at the moment. But it is nowhere there that you have to wait till 90 days to
No,
send
no,
the challan.
he may not be required to wait for 90 days.
That is what I am coming to,
The
Lord.
records will not be transmitted. The challan would not be transmitted. You have a different answer to it. Your answer would be that this is the way in which the minimum time is to be taken. Question is that everything is videographed.
Lordship,
Things have been captured in camera because it's all digital.
Lordship,
So therefore, there is little scope of any argument.
Lordship.
Now, can you tweak this SOP? Can it be thought of making changes in this SOP where if the person, the noticee who receives the challan, if he decides that no, he shall not pay, he will go to court. In that case, you segregate his case and send the challan to the court. That's all.
No, that
This
is,
could be thought of.
no, that is what I was coming to. Lordship.
His entire argument, the wind of the argument would be taken away if you do this.
That is what I was coming to, Lordship. Now, once a challan is issued, what is presently being done is wait for 90 days. If it is not disposed of within 90 days,
Send it to court.
send it to court. If the moment a challan is raised, Lordship, same time it is sent to the court, notice or a summon is issued from the court, he gets the time of 90 days to challenge. He gets a window of 90 days to agitate his grievance. Now, if that is so, Lordship, if that can be so, then there could have been no grievance. He can agitate it. He need not wait for 90 days. Now, that is missing, which I do humbly. That is
So
missing.
if a person communicates to the transport department that, look, I am not, I do not accept this guilt.
Lordship,
I am not ready for composition, be it even for 500 rupees.
Lordship,
I'll go to court.
Lordship,
In that case, you pick up his challan, transmit it.
Lordship.
End of the matter. Why all this argument for
Lordship,
international declaration and all that?
Lordship, Lordship.
Outer
Lordship.
limit, you don't put
That
that
is,
out.
that is, otherwise this, working is, yes, working is creating some
It
difficulties.
is not creating some difficulties, it is creating difficulties for few who would contest it, who are extra sensitive,
That
who
is-
find that, well, I have been rendered and accused without my having committed the fault. So why the systemic delay in court is not going to trouble them, but with the government, it is difficult. With
Yes,
the government department, it is difficult.
Lordship,
So you can, it's always, law is dynamic. So
Lordship,
this SOP does not have any statutory force.
Lordship,
It could be changed by a mere notification of the government.
Lordship.
So you can think about it. We can say that this could be the outer
That
limit.
is,
That-
that's Lordship.
Nothing, it's no big principles are involved here.
Nothing, otherwise, Lordship, so far as the applicability of 167A is
Therefore, I
concerned.
use the expression de minimis non curat lex. Law should not take notice of small petty things. It means nothing.
Lordship.
A traffic violation accused is not an accused simply.
It's not an,
For the positive of any other explanation, any other expression, so to say, the word accused is used.
Lordship. Even otherwise, Lordship, so far as 167A is concerned, Lordship.
Your
That-
affidavit, the affidavit filed by the traffic person,
Yes, I have
which
seen
is
that.
read, it tells you the working pattern.
That is what.
You can only think of bringing about this change or suggesting this change to the
Lordship.
extent that if a person does not accept composition, he wishes to contest this, you transmit his records to, transmit the challan to the court. That way he can go and
Within that 90 days period, Lordship.
whatever,
Yes,
within any time. Not 90 days window is for the person who would ultimately pay,
Lordship.
A person who on the next day decides that no, he is going to go to court, he is not going to pay. Let him send his.
Why has,
I think they have just missed out. It's inadvertent. Otherwise, they would have not have made it. There is no question of any forcible composition.
no, Lordship.
Because when it says that if you don't pay, the matter would automatically be referred to the court. That
Yes.
means there is no forced composition.
Yes, Lordship.
But he says that because of this, the fallout, the waterfall effect is forced composition. Otherwise, for 90 days, nothing shall be done.
Lordship,
That
Lordship.
you appear for which party?
Transport.
Transport.
Ultimately, I have a look, my affidavit, page 124 regarding integration of each challan with the virtual court. We have taken some steps.
Base,
Page 124, the affidavit filed by.
Yes. What have you said?
Also, paragraph 4, my lord, 124, may I read, my lord?
Hmm.
That the deponent begs to state that in regards to the integration of each challan with virtual court, the following steps have been taken by your deponent. That on 1/6/23, a meeting was held at the office of the Commissioner of Transport Assam with the National Information Center. In the office of the deponent requested the National Information Center to take necessary steps for integration of each challan with virtual court system and to put a send to court option in each challan. Point number 7 of the manual is annex, lordship. NIC to take necessary step for integration of each challan with virtual court system and to put a send to court option in each challan against all offences, my lord. That we have annexed. Then point 2, that on 26/23, a letter was issued by the office of the deponent to the registrar of the Honorable Guwahati High Court requesting to take necessary step to provide permission to integrate send to court option in each challan against all offences so that it can be configured by the National Information Center, Assam. That letter also annexed as B, my lord. Then the subsequently by letter at 5/8/23, the Joint Registrar of the Honorable Guwahati High Court has communicated that the matter regarding integration of
There's
the.
something different.
Yes.
Now, the challan has to have an option of send to court,
Yes, my lord.
but no time limit has been fixed. No, send to
Yes.
court means when? When do you send?
Immediately. That we are going to take this step
Immediately.
immediately.
So a noticee has an option to either go to court or.
Court, okay. Yes. Then the last letter, lordship, I have annexed.
Simultaneously, it is integrated.
Yes.
Challan is sent to the noticee as also to the court.
Yes.
It is the option of the noticee whether to make payment or go to court to pay.
Yes, my lord. Did the last annexer,
Then I don't think any change
Yes.
is required.
then annexer E, my lord,
No, no.
this is
Has it been integrated now?
it's pending before this register of the Honorable High Court, my lord. This letter, last letter we have written to the Honorable Registry on 6/8/2025.
No,
This is Annexure E. I have Annex, my lord.
no, send to court is one of the options.
Lord.
Now, that option has to be explored, that if a person wants to go to, simultaneously, if you
Yes.
send it to court,
Yes, ma'am.
then perhaps the option is with the notary. He
Yeah.
pays or contest.
Yes, my lord.
Then he should get an
So
Indian
this
notice
90 days window is not necessary. 90 days is
for
when
payment.
90 days compulsorily, if no payment is made, then you remove all records from your end and send it to the court.
No, lordship. For these steps we have taken to simultaneously send to the notice and send to the honorable court a notice. Then they may contest before this honorable court. This Annexure E, my lord, may kindly have a look.
Why did you not point it out when Mr. Mishra was arguing it?
Senior counsel is arguing, so
No, you could have said no, you could have taken the leave of the court. I would have permitted you.
that I have
We
Annex.
could have
affidavit, I
finished the
have-
matter. There's no need to decide this issue, no?
Affidavit I have filed, I have,
So you don't expect the court to read every line
No,
of the
no,
every
I'm
affidavit.
not-
You have to point out,
Yes.
no?
my senior has already gone
This
through this.
addresses his defect. Mr. You're assisting Mr. Mishra, no? Please tell Mr. Mishra that this is what has been contemplated. Now it will be contemporaneous.
Yes.
Notice to you, at the same time the challan would be sent to court. Your option. Don't wait for a day, go to court or make payment. Correct? In that case, this petition fails. Why I mean, you have, Madam Counsel, what's your name?
MD Bora.
MS Bora, you have done a good job by filing this affidavit, but then there was something lacking here. We would not have, spent so much of time.
The senior counsel is arguing.
Huh? No. In these matters, when you find that the entire result would hinge on this,
Lordship is regarding the transport challan.
you would
Regarding
not,
traffic, we are
you
not.
would not be, you would not be breaching the court protocol or the system in which the arguments are to be advanced. If you just raise your hand and say that here, this is the issue which I wanted to before the.
I apologize, my lord.
No, don't apologize. We are happy. This is not required to be done.
Lordship, may kindly have a look Annexure E.
That's all right. We'll put it to Mr. Mishra. Why then do it? Why do we unnecessarily burden the already existing load of
Yes, I understand, my lord.
case mine load? Why?
I understand, but senior counsel is arguing, so it's not.
What is his name?
No. Be present.
Inform Mr. Mishra. This is if he still wishes to contest on that the SOP should go. SOP is non-statutory. It's just it's internal communication for the purposes of ease of business. So in that case, if this is what is being done, there is no challenge. And your grievance is redressed to the extent of 99.9%. Please have a word with him and then tell us. So we conclude this. We'll keep it on another day. On that day, if you say that we have to deal with your points, we'll deal with it. Otherwise, we'll say all this was the. How we can dispose it of?
Yes. Lordship, may kindly have a look Annexure E. We have written to the Honorable Registry of this. This pending. I have requested them to as soon as possible.
He did not notice this. This was not placed.
I personally requested my learned senior. We have done that much that we should give to the learned senior council.
Take a call. Ask Mr. Mishra. If he's still willing to, pursue this petition, we will dispose it of. Wait, tomorrow? Tomorrow means Monday?
Tuesday, Lordship. Monday is a holiday.
Arguments to continue. Let this matter come up for consideration.
Obliged,
I'd like to highlight matter. Presently, my lord, within the Kamrup district, my lord, more than 1,44,000 cases pending, my lord, in the virtual court, my lord. Only one designated court is there, my lord, Civil Judge Junior Division, my lord. Therefore, my lord, concerned Chief Judicial Magistrate, he has written to the district judge also, my lord, for set up the designated court, my lord. That is the
That
problem.
issue, you bring it to the notice of the Chief Justice in his administrative side, we will see, but it has got nothing to do with the issue which has been raised here, no?
My lord.
Ah. We could have done it now, but we don't want to do it behind the back of Mr. Mishra, who is arguing. So we ask him, he may not come.
I'll
This
get
is-
back with the answer.
So we will dispose it off saying that this is what is being done.
Right.
It is pending at the level of ICT. Internally, in the state of Assam, it shall happen that well, dispatch would be contemporaneous.
My lord,
Arguments
I
to
may submit that letter also, my lord, because
That's
this
fair.
has to also be taken.
That's completely extraneous to the facts of this case.
Even my lord, pressure of the court, my lord.
We don't take it on board. Now this is a challenge to the, of course, there's a PIL. PIL we can. You file it, we'll see. You file your document, we'll see.
My lord.
But not later than tomorrow.
Tomorrow it's a holiday.
Holiday, my lord.
Tomorrow
In-
means
in-
the next working day, Bob. We don't have to
Ma-
explain this to
ma-
the bar.
The-
When I say tomorrow, it means Monday. Whenever,
Tuesday.
Tuesday.
When the matter is fixed.
So we are fixing it on Wednesday. Wednesday. Arguments to continue? Let this matter come up for consideration. But we have wasted 1 hour. 1 hour was consumed. You could have shown this.
Item 12,
Payment of gratuity. Yes.
Yes, sir.
Yes. This appeal was referred by the appellant in respect of two writ applications, your lordship, which have been dismissed, your lordship. That it was time barred. The issue was that he was dismissed from service in the year 2019, 1919.
1999.
And he was dismissed from service. He was joined his service in the year 1973. The misconduct was there, and the special judge has sentence was there, and he served his sentence.
Give us 1 minute, sir.
And the sentence.
Just 1 sec. 1 sec.
Yeah.
Payment of gratuity. completely forfeit. But pension will be like to, mm, what nature of that? There has to be order. It cannot be, it is not a, it is not the automatic committee. And so many- Yeah. For fixed to- but then it has to be. To be, that it will be there. But a separate order. has to be, no? It's not automatic, no. There must be some order. Must, it's. Isn't it? I think it will be in the, okay, it we can. Get it, but there has to be another administrative around of keeping it. Have you annexed the order of dismissal?
Yes.
Where is that?
It is, it is start from your office.
Dismissal where?
192,
One?
page number 192.
192.
And also in 193, my first petition in which I was a councillor.
Just show us the letter of the
Yes, from 192.
dismissal from service. 192 is the order.
The Indian order, Your Honor. So dismissal from service, Your Lordship.
Page 61,
Page?
61.
Where is the administrative order of forfeiture? I'm asking you, Mr. Chaudhary. Where is the order of forfeiture of gratuity?
There is no separate order, I'm told.
So it,
In fact, that issue never came up before the learned
but it
single.
can't be automatic, no. A decision has to be taken. See, unless the order of dismissal stipulates, you have to pass an order.
That I appreciate, but what has happened, if
No,
your
no.
lordship is,
We are not concerned with all those facts.
The writ
Mr. Chaudhary,
petition-
We are on question of law, whether it could be
I appreciate,
automatic.
the writ petition has been dismissed on the ground of delay in latches. So on that issue never cropped up. So I don't have specific instructions as of now whether a separate order has been passed on.
And also approach was made, Your Lordship. Page 28, Your Lordship.
No, court speaks whether automatic or. That could be done on 4/6 is all right. There is no question of his claiming for gratuity now if there is a positive order, but it can't be automatic. Either the letter of dismissal would indicate that for these reasons, because of conviction on grounds of moral turpitude, not moral turpitude, gratuity is forfeited. That has not been done. He never questioned it, and 22 years. passed by
Lordship,
then.
page 28, Your Lordship. Approach was made. Page 28. Of our first writ application, Your Lordship.
Page
Page 28. It was page 28, Your Lordship. We filed one page 10 of our writ appeal, Your Lordship. Approach made by the appellant, Your Lordship. To MS Mita Prasad, Your Lordship. His station at Dehradun, Uttarakhand, Your Lordship, asking the subject matter was payment of gratuity in respect of Sri Sarat Chandra Bargohain. This is appellant, Your Lordship. Approach was made, Your Lordship. Never been answered. Never been answered. That
But they gave you the CPF, your contribution.
CPF hasn't been paid.
has been paid.
But he, by the same letter of request, he had asked for gratuity also.
Yes, he is.
That went unresponded. You should have said
Yes.
that we have
You are not
completed
entitled.
your gratuity in terms of the power to the employer under 4/6.
That,
Take instructions, tell us. There must be some order.
but
Otherwise, you can't keep somebody's money. That's his property. Unless you
it gives us the power under the,
who disputes it? Nobody is disputing your power to forfeit wholly. Not to the extent of damage, but wholly. But where is the order?
that, my lord, as I pointed out, before the learned single judge, I was not there. This issue never cropped up because the matter went on the issue of
We can't,
delay and latches.
we can't dispose of the petition by saying that it was never questioned.
True, I appreciate.
Because it concerns his rights. Even though 25 years, 30 years later, if he comes up with this, it remains continuing. Here, the laches principle will not apply. He has been contesting.
But-
Several writ petitions have been filed.
Started contesting after 20 years. His conviction was in 99.
Whatever it is, we are not for a minute suggesting that pay is gratuity.
My lord,
We
I
need an order.
appreciate. That must have been passed. Your lordship will fix it on.
The appellant is a formal employee of Oil and Natural Gas Corporation Limited, bracket ONGC, who was dismissed from service sometimes in the year 1999. He was also convicted in the criminal case, and the conviction was sustained up till Supreme Court. However, after his dismissal, he was paid his contributions of the CPF, but was not paid his gratuity amount and other entitlements, including leave encashment, etc. Multiple writ petitions were filed by the appellant before this court, seeking such relief, but all were rejected. Lastly, the appellant claimed his gratuity amount and other entitlements and his other entitlements, but the same was rejected by the impugned judgment on grounds of laches and delay. The demand for payment of his entitlements was made 22 years after his dismissal from service. However, from the letter of dismissal of the appellant, we do not find that any decision was taken in terms of section 4(6) of the Payment of Gratuity Act 1972 for forfeiting the gratuity amount due to the appellant. Mr. Indranil Chaudhary, learned advocate representing ONGC, submits that he shall take instructions in the matter. The law with respect to forfeiture of gratuity comments that it cannot be automatic, but a decision has to be taken for such forfeiture. Let this case come up for consideration on.
We need some time.
You just inform us orally.
That is the problem. That is what my young friend was telling me. The officers have been shifting multiple times. It might take some time to trace out the record.
Officers may come and go, the records remain.
That is what.
2 weeks.
But
See,
can it be towards the end of February?
why not? But he has himself come after 22 years. So we can, end of February, all right. But then we must know if there
Yes,
is an
sir.
order, good.
Date
27th of February.
26.
Hmm?
26.
26th.
26. Deeply obliged, doctor.
All right.
26. 26. 24.
We have heard Mr. R.P. Hazarika. Your R.P. Hazarika.
Yes.
Mr. R.P. Hazarika, learned advocate for the appellant, and Mr. Indranil Chaudhary, senior advocate for ONGC.
Obliged. Item 13.
May it please.
Where is Mr. Chaudhary?
You'll be joining.
Yes, Mr. Katniar.
Yes, madam. Minor will find the impugn judgment.
Plus, just a minute,
Yes,
let's
madam.
see our order.
Yes, madam.
Hmm? Yeah. Only- Yeah. Continuous. The order was that. Right, well, ఇంకా చూస్తారు. Oh. Yes, where is Mr. Chudhary?
It on that in port number 23, I.
His argument has been noted in our earlier order. He needs to respond. Here, Mr. Khatiniar, learned advocate for the appellant state is present. There is some difficulty in Mr. HR A. Chaudhary appearing as of now as he is engaged in another court. Let this matter come up for consideration. We fix a date. What date?
Any lordship. Next.
Next, it goes in February. Mid-February.
24th February.
Today is what, Thursday? 19th of February.
Oblige, lordship.
Needs to respond.
Lordship.
Let's stop it.